Hi everybody, my name is Kathleen Scott and I'm the managing partner of the Scott Wagner Law Firm. I'm here to help everyone understand their rights and obligations under two new acts that are passed by Congress. One is the Emergency Family Medical Leave Act and the second is the Emergency Sick Leave Act. So hopefully everyone can hear us. I apologize, we got a little bit of a late start because there was some technical difficulties. So I have started back from the beginning again. I apologize. Hopefully this time, the third time will be a charm. So welcome everyone to the Scott Wagner Law Firm Facebook Live. So we're going to cover the Emergency FMLA Expansion Act. We're going to talk very briefly about the Unemployment Compensation Act that was enacted by Congress and the Emergency Paid Sick Leave Act. So let's dive right in. So the Emergency FMLA Expansion Act has amended what was previously the Family Medical Leave Act, which is a law that was enacted in 1993. Traditionally only applied to larger employers, those with 50 or more employees under the FMLA. In 1993 were required to offer paid time off to eligible employees who had a serious medical condition. They also had to keep their job open. Under this new Emergency Family Medical Leave Expansion Act, the Congress did a couple of things. One is they reduced the number of employees that this law applies to. So if you have less than 500 employees, this law applies to you. So big companies like Walmart, Target, large hotels, airlines, they don't have to worry about complying with this. This is small businesses, or at least what Congress has defined as a small business. All businesses with 1 to 499 employees must now offer paid time off to their employees. So you are covered if you have fewer than 500 employees. That's an important distinction. There are certain exemptions that the law is going to allow. What you should understand, though, is that the Department of Labor has the right to issue regulations defining who is exempt. We know from the language of the statute itself that businesses that have less than 50 employees might be exempt if they can demonstrate that complying with this law would jeopardize the viability of their business. We don't have the interpretive guidelines that tell us what that means. And so the safest course of action, if you're an employer out there that has fewer than 50 employees, you're not exempt until you understand what that exemption means. The Department of Labor issues those guidance. Healthcare providers and emergency providers are also exempt from the law. Again, we don't have any clear definitions as to what circumstances need to apply for those exemptions to kick in. So the safest course is for every employer to comply with this law. Now, who are the employees that are eligible for any benefits under this new emergency FMLA? If you're an employee that has worked somewhere for 30 days, 1 month, then you're eligible. So all employers less than 500, that's the employers who are covered. All employees who've worked for less than 30 days, they are covered under this new emergency statute. And those employees are going to get, if they have a qualifying need related to what's called a public health emergency, then they get paid leave. So what does that mean? So under the law, if you have less than 500 employees, you're going to be required to pay leave for employees who are unable to work or telecommute if they need to take care of their children whose schools or daycares are closed due to the COVID-19 outbreak. There's also a right to reinstatement, which we'll talk about in just a moment. So here's the good news. There's only one circumstance that employees get paid leave under this new law, and that's if they can't work because kids' schools or daycares are closed. That's it. Let me dispel some myths that are out there. You do not have to offer paid leave if employees are sick. You do not have to offer paid leave for employees who have to go home and take care of sick kids under the FMLA Expansion Act. We'll talk about how this act interacts with the Sick Leave Act in just a moment, but for compliance with this particular statute, it only allows for paid leave in the event you have to stay, one of your employees needs to stay home to care for small children whose schools or daycares were closed due to COVID-19. All right, so what is a qualifying need due to a public emergency? We just talked about that. A child care provider means somebody who receives compensation for providing child care. So if you have a daycare or you use a religious organization to care for your child and they are no longer able to stay open because of COVID-19, then under this law, you might be entitled to paid leave by your employer. Okay, so how does it work? It's unpaid leave for the first 10 days, and then it's paid leave after that for up to 10 weeks. But certain qualifications have to happen. The employee has to continue to be eligible for the leave to get the full 10 weeks. An employee can also use any paid time off that they may have in order to make those first 10 days to be paid. But that's at the employee's election. That's not at the employer's request. That's a little bit of a divergence from some FMLA law previously, so let me just say it again. When leave starts, the first 10 days are unpaid, then thereafter they are paid. If the employee has accrued time off, like vacation or accrued sick time or PTO, as it's called, paid time off, they can choose to use that to cover those unpaid days, the first 10 days. All right, so how much does employers have to pay? Well, they have to pay either 2/3 of that employee's paycheck per day, but it's capped at $200. So the employer will have to calculate what is 2/3. If it's over 200, they only have to pay the 200. And they have to do that for up to a $10,000 aggregate, essentially 10 weeks, right? So that's where we get the 10, that's how the math works. 200 per day for 10 weeks is $10,000. So the employer has to pay that out of to the employee. So how, just to kind of give a little chart to run through this, if your child's school has closed because of COVID-19 and that child requires childcare at home, you are the primary caretaker and you cannot work because you need to be home with your child, you can qualify under this Emergency FMLA Expansion Act for paid leave. First 10 days you don't get paid. The 11th day you get paid up to $200 a day or 2/3 of your salary for up to 10 weeks, as long as that situation doesn't change. Second it changes, you don't qualify for the leave anymore. So if your spouse or domestic partner is now able to come home and take care of the kids, then both of you can't qualify for leave. That's how that works. So if your circumstances change, your entitlement to the leave changes as well. There's a second aspect to this emergency FMLA paid leave expansion, and that second aspect is the right to reinstatement. So it's a very similar FMLA principle, right? The employer is obligated to hold that position while that employee is out on FMLA. That's true under this law as well. And when that employee comes back, they need to be restored to an equivalent position with equal benefits, pay, other terms and conditions of employment. That means you can't demote an employee because they were just out. You can't fire them because they were out. They have a right to their same job, and to the extent that job is not available anymore, they need to be off a position with equivalent pay and benefits. So that's an important distinction. Congress did write into the statute an exemption for employees who have less than 25 employees. This exemption only applies to that right to reinstatement. So in this scenario, if you are a smaller business with less than 25 employees, you do not have to have a right of reinstatement. In other words, you don't have to hold that job open if you meet the requirements under the section. And this is section, it's the new section of the FMLA bill, and it goes through what has to happen in order for you to qualify for that exemption. All of these must happen. First, the leave that's at issue must qualify, meaning home to take care of a child whose school has closed. Second, the position can no longer be available, meaning the employers had to eliminate that position as a result of this COVID-19 outbreak. Third, that the employer has to make every effort that's reasonable to try to bring that employee back, even if their own position was eliminated, to see if they might be able to fill some of the other open and available positions. And this last one, which is particularly onerous on the employer, they have to continue to reach out when positions become available to try to use those employees who lost their job to fill those positions. And they have to do that for up to a year. And that's calculated based on the date that the FMLA leave ends, or 12 weeks from when it began. So that's how that works. So provided that the employer has done that, they've tried to place them, they've been dutiful, the position has been eliminated, and the leave was taken due to COVID-19, they could be relieved from the obligation to have a right of reinstatement. What that means is you shouldn't be sued for not reinstating the employee if all these circumstances have been met. The law also requires that an employee has to give as much notice as they can. So if you're told on Friday that your school or daycare is going to be closing the following Tuesday, you need to tell that employer on Friday or soon thereafter as you can reach someone. You can't just sit back and wait for it to happen. And so that's the employee's obligation, is to give as much notice as practical under the circumstances. And that's it for the FMLA, Emergency Exemption Act. So just to summarize, it applies to all employers with less than 500 employees. There's one type of leave that you're required to offer if you're an employer under this bill. Just one type. It's if someone is home taking care of their children because their schools have closed or their daycare has closed. It does not matter whether the employee is sick or whether the kids are sick. It just matters that the primary caretaker is home and needs to take care of those kids. If that's the situation, then they get paid leave, first 10 days unpaid. Days 11 up to 10 weeks are paid, capped at $200 a day for up to $10,000. This law takes effect April 2nd, and it will sunset. It'll expire on December 31st, 2020, unless Congress extends it. That's a quick wrap up of the FMLA. Now we move on to what is the easier topic here in this live webinar is what about unemployment rights? What does the employer have to do? It's very simple. If you have to lay off employees as a result of this, or even temporarily lay off employees or furlough them, as some people like to refer to that, or they get terminated, any situation that happens that causes an employee to not earn wages is going to be a qualifying event for unemployment compensation. And all you have to do is the employers tell them you may have a right to receive unemployment benefits and then direct them to the unemployment compensation website. There may be more specific notice that you need to give them at a later date. The DOL might amend to provide some interpreting guidelines to help people with the exact language. But for now, just direct everyone to the floridajobs.gov website to apply for what is known in Florida as the reemployment opportunity assistance. That is the name of the website in Florida, but it's Florida. You can get there from floridajobs.gov. Just direct your employees there. Okay, for the third part of the seminar, we talk about Section 5101. This is a new requirement for all employers, less than 500 employees, to provide paid sick leave to employees. So this is a federal statute. It's brand new. There's never been anything like this previously. And so here are the situations. An employer must give paid sick time to an employee if that employee is unable to work or telework because of any one of the following conditions. 1, that employee is quarantined or isolated related to COVID-19. Number 2, the employer has been advised by a healthcare provider to self-quarantine due to COVID-19. Number 3, the employee is having symptoms of the virus and seeking a medical diagnosis. Next one is the employer is caring for an individual who is self-quarantined or has been told to self-quarantine. Number 1 and 2, or the employee is experiencing any other substantial similar situation, or the employee is caring for a son or daughter under the age of 18 if their school or childcare is unavailable as a result of COVID-19. So if any one of these circumstances exist, then the employee is entitled to paid leave. So let's talk about what that looks like. As with other parts of this emergency bill, there's an exemption for healthcare providers and emergency responders, meaning they don't get the paid sick leave. There's also different amounts depending on whether the employee is full-time or whether they are part-time. So full-time employees, they get 80 hours of sick leave. For part-time employees, the statute says that an employer has to pay a number of hours that is equal to the number of hours that such employee works on average over a 2-week period. So averaging out if they work 20 hours over the last 2 weeks, then under the law, they would get paid sick leave for 20 hours. That's how that works for determining how much they get. Now, what's the dollar amount? Here's how the dollar amount works. So up to $511 per day, or $5,110 in the aggregate, if the employee is under a state, federal, or local quarantine or isolation related to COVID-19. Second, if the employee has been advised by a healthcare provider to self-quarantine. Or third, the employee is experiencing symptoms and seeking a medical diagnosis. You'll see that these are the first few items that we talked about in that first checklist. So if the employee themselves is quarantined, isolated, or been advised to be quarantined or isolated, or is having symptoms, they get $511 per day payable by the employer, or up to $5,110 in the aggregate. It's different if that employee is sick because they have to care not for themselves but for a minor child, and they get a lesser amount of money. They get $200 per day. So in the event that the employee is caring for someone who is quarantined or isolated or sick, then they get $200 a day, up to $2,000 a day in the aggregate. And that's also true if they're caring for a son or daughter whose school or daycare has closed. They get $200 per day in the aggregate. That's the amount of sick time. So couple of interesting points. Sick leave doesn't carry over. So this isn't like a bank that the government is telling employers to fill up for an employee and they can cash it out at the end of their employment or carry it over to another year. The need for sick leave begins when one of these qualifying conditions occurs, and it ends when the leave ends, when the employee comes back to work. Also, the employer cannot make it the employee's responsibility to find a replacement for them. So if you're working in a restaurant that's doing takeout and you now have been exposed and have been told by a medical provider or under order to self-quarantine, the employer can't say to you, that's fine, Sally, you can be off tonight, but you need to find someone to cover your shift. No, that doesn't work that way. It's the employer's obligation. So make sure, employers, that if you have policies like that, which under ordinary circumstances might be enforceable during this COVID-19 outbreak, which starts April 2nd, to the end of the year, during this period of time this law is in effect, you cannot require the employee to find their own replacements. That's your obligation. So another aspect is when the employee is on sick leave due to one of these qualifying circumstances, you cannot say to them, first you need to exhaust your own personal bank of paid time off or vacation. It doesn't work that way. Under the Sick Leave Act, you, the employer, have to pay the sick time and then allow that employee to continue to bank their PTO for that qualifying condition. In other words, you can't make them say, we're only going to pay you sick leave under this law once you exhaust your paid time off. No, it doesn't work like that under the sick leave provisions. So it is challenging to figure out how these two, the FMLA that we talked about a moment ago and the Sick Leave Act, how they work together in tandem, because there are some nuances, and that is an area that we're hoping the Department of Labor can give some guidance to. My firm has been active in trying to obtain some of that guidance now, because we know that under the FMLA, as a reminder, the first 10 days are unpaid. And you can allow an employee to use their paid time off if they're home taking care of a child whose school closes. But the same law also requires that they get up to 80 hours of paid time off and not allowed to use their PTO. So we're hoping to get some guidance on how an employer can comply with both of those laws at the same time. And we'll stay tuned to us. We'll help you navigate through this as these circumstances arise. The law also requires that an employer post a notice in the workplace in a conspicuous place that tells the employees about these new rules and regulations. And so because a lot of businesses are closed and people are only telecommuting, this makes it a little more challenging. I would encourage everyone to use email, text messages, verbally read, whatever you have to do to be able to get this information to your employees. A model notice is due on Thursday from the Department of Labor, so as soon as that's available, we will post it to our website and to our Facebook page. Also, you should know that if you have employees that English is not their first language, it's a great idea to do this notice in every language that you have spoken in your workplace, and the Department of Labor does a great job of doing that, and usually in Spanish and Creole. We'll make sure our postings include that as well. So stay tuned for that posting. Please be advised, employers, that it is illegal is the claim for wrongful discharge. In fact, if you discharge, discipline, or discriminate against an employee who takes leave, sick time in accordance with the Act, or who has filed any complaint or caused to be filed any complaint related to sick leave under this Act. It also includes testifying or is about to testify in any proceeding. It's hard to understand how that would apply, but in any event, no adverse action should be taken against an employee for their utilizing their rights under this statute. So you can't fire an employee for taking sick leave. You can't treat them differently and say, oh, that person is out on sick leave, now we're going to give them the worst shift ever because they had to take those 10 days off. That would be an example of discrimination. So the violations are real. This act amended the Fair Labor Standards Act. That's the overtime and minimum wage federal law that when it's violated, employees can seek not only the back wages, but double damages called liquidated damages and reimbursement of attorney's fees and costs. So these are expensive violations that should be avoided, and frankly are easy to avoid as the employer. You just need to offer the paid leave. I'm not saying it's not inexpensive, and not treat employees differently for utilizing it. So Section 5107 of the law also says that the law is not going to be construed in any way that could reduce or diminish the rights that an employee has under their existing policies. So that's a little bit of a challenge when you're dealing with the paid time off. And again, this is an area that we're trying desperately to get guidance on. And so let's walk through an example. If an employee has to go home to care for a loved one who is sick under quarantined, they may be eligible for paid time off, right? We can't substitute their paid time off under their handbook for the obligation for the employer to pay those 80 hours of sick leave time. We know that. So they need to be paid up to up to $511 a day if they're sick. But in my hypothetical, they were caring for someone who was sick, so they would only get the $200, the lesser amount of the sick leave. If they need to stay out, then they might continue to qualify under the FMLA leave. However, they would only qualify if the reason they have to stay home is to take care of a child whose school is closed as a result of COVID-19. So it is a little bit odd that if the employee themselves is symptomatic and goes home, there's a question as to whether that employee may qualify for FMLA leave. They certainly would qualify for the sick leave. It's unclear whether they would qualify for the FMLA. Certainly the paid aspects of it would seem doubtful. So whether that was an intention of Congress or not, it's certainly based on the black and white language of the law. It's certainly questions that we have. Okay, so if you're an employer out there and you're listening and you're saying, oh my gosh, what do I do? First, it's time to revamp your policies. It doesn't have to be complicated. You just need to adopt these. They're not going away until the end of the year, so you just need to adopt them. You need to get that notice. You can download it from the Department of Labor's website. It's due out on Thursday. And most importantly, you need to communicate regularly with your employees to really understand what's going on with them so that you can make the best legal decision about what they're entitled to. And we're certainly happy to help with that. Our firm has put together a consultation flat fee package that will speak to employers out there, make sure they understand the remedies, draft handbook and policy addendums for them to circulate to their employees that are compliant with these new laws. So the burning question is, how is the employer going to pay for this? How does it work? Well, starting April 2nd, the employer will be allowed a tax credit for any paid sick leave that they pay. In fact, employers are going to be allowed a full credit up to 100% of all qualified sick leave wage payments that the employer pays with respect to that calendar quarter. So let's walk through an example. You have two employees that are out because they are quarantined or they're sick or they meet a qualifying requirement, and you've spent $2,000 in quarter two paying them these 80 hours of wages that they're owed under the Sick Leave Act. So when it comes time to pay your second quarter 941 payroll report, when you calculate your obligations to the government, to the IRS on there, I think it's the Department of Revenue, you get to subtract the $2,000 that you've paid these employees. It's a 100% deduction. So that employer is going to get back the money as a tax credit and not owe it to the government. I've put in the slides the exact language of it. It says there should be allowed as a credit against the tax imposed under Section 311A of the IRS code for each calendar quarter, an amount equal to 100% of qualified sick leave wage paid by such employer with respect to that calendar quarter. That's legal mumbo jumbo, but breaking it down, if you pay sick or FMLA wages during a quarter, you get back as a credit whatever you've paid as an offset to any tax liability you may have for your payroll taxes. Kind of breaking it down. I'm not a tax attorney, but that is my layperson's employment lawyer understanding of how this is going to work. Of course, it hasn't happened yet. It takes effect April 2nd. So I would caution employers who are out there who might want to pay it right now, because you're still in the first quarter. And we don't know, since the law doesn't take effect until April 2nd, we may want to flush that out. That's one of the numerous questions that we've been asking for clarification on. If employers pay this now, can they get the credit now even before the effective date of the law? So that is something to consider. Another little bonus that employers get who do pay FMLA under the law and the sick leave under the law, they will also, those payments are not themselves considered wages, so therefore the employer is not going to have payroll taxes on those particular items. So as I've said repeatedly, the law takes effect April 2nd. It expires at the end of the year. Both laws, the FMLA and the Sick Leave Act, start and end at the same time. So I know some employers are out there right now trying to make decisions about laying employees off, paying them severance, or how to handle this. They might want to factor in that date and making those considerations, because it might be more tax advantageous for them to pay sick time off to employees. Just something to think about. as opposed to severance. So there's a language in both bills that really requires underscoring and paying attention to. So these acts only apply if individual workers can't work or telework. And so I think a big takeaway for employers out there is, if you haven't already, you need to set up remote working policy if practical, because that is going to be the difference between whether you have to pay this paid time off or not. So employers who allow employees to remote access, if they can. I know that that's not always the case for personal service industries like massages or for nail salons. You can't do that remotely. But for those people who can work remotely, I would urge employers to adopt all the policies they can to allow that to happen, because it will effectively keep their business moving, but also relieve them from the obligations of paying any FMLA or sick time under these new laws. But with every problem we solve, we also create some new considerations. And so let me just say to people who are out there who do have remote workers or are setting up a remote worker, just pay attention to some minor issues, like make sure that your company has a policy on how to protect its data. So if an employee is using their own computer to log into the employer's system, you need to have a policy that protects the integrity of your data. You need to have a policy that says what happens in the event of a separation with that employee. Can you wipe the data? As lawyers, we're always very concerned, obviously, about the confidential nature of our client data. So we want to make sure employees who are using their own devices, we have a policy to be able to address that. Also, take care to make sure that remote access doesn't become permanent, because becoming permanent is going to bring a whole host of new issues. And so while it's a great idea, employers might want to make it clear that this remote access is unique to the COVID-19. They're not changing their policies moving forward. This is just a response to this emergency, unique situation. The reason I raise that is because employees might see this as an opportunity to always work remote, or work remote in other circumstances, like in the future when their child is sick, or in the future when they have a headache. So we don't want to create, and maybe you do or you don't, but you want to give some thoughtful consideration to whether it's your goal to create a permanent remote working situation or just a temporary one. Some employees are moving out of state to be with loved ones during this crisis, and so that creates another issue. So the longer they stay remote, particularly in another state, that raises issues such as, well, now do I have to pay unemployment in those states where they're now situated, or workers' compensation? So the longer an employee is in a different state, the more like a resident of that state they become, and that will raise the employer's obligation. Also, take care to define how many hours a day you anticipate that employee to work while they're working remotely. Track their hours. There are online software that will allow you to do that, because overtime and hour tracking obligations are more challenging, but they apply just the same to remote workers. So you want to make sure you're not creating a situation for employees to work a bunch more overtime than maybe have unintended financial consequences. So just a couple of thoughts on remote workers. I've been getting asked a lot of questions about how to handle sick employees when they're coming to work, and some talking points for managers. At this point, I think you have to be living literally in a bubble to not know that the current recommendations from the CDC and from the governor of many states is to shelter in place. Some states have orders requiring you to self-isolate or shelter in place. And in those situations, people should not be coming into the workplace. And so that sort of resolves this issue of whether they should be coming in sick. The advice is to act as if you have the virus. That's the safest thing to do to not spread the virus to others. I think any policies, like if you're allowed to bring your kids into work, we need to be rethinking those policies during this particular period of time. As employers, you have an obligation not only to your sick workers, but to keeping the rest of your workers from getting sick as well. OSHA has record-keeping requirements, and so it's been asked, does COVID-19, is this a reportable incident if an employee gets infected as a result of performing work-related duties? Certainly that is an ongoing question. I have posted the OSHA standards on our website, and the link is here. And so there are certain situations where there are reporting obligations for employers to in fact report to OSHA those situations, and here they are once again for OSHA guidance on that. For the OSHA guidance, let's go back to that for just a moment. employees are asking me, well, I'm coming into work, but I'm working next to someone who's clearly symptomatic for something. What's the employer's obligation? Can they send those people home if they're not following guidance? I'm also being asked questions for individuals who work for healthcare providers. I'm going in and I don't have the necessary PPE, protective equipment, to do my job safely. Can I refuse to work, or will I be terminated? Is that legal? And so OSHA has now issued specific healthcare related guidelines that are up on our website and are posted in this presentation, and that will hopefully give us a little bit of light on that particular question as to what is required. All right, so workers' compensation is another question we've been asked a lot about. If I get sick at work and I contract COVID-19 from a coworker, is that a workers' compensation claim? The answer is no, unless maybe. So no, probably not, unless you're a healthcare provider, and because you might then have exposure that is of a greater type of exposure than, say, the average worker. It's a heightened standard, and if you're more likely to get sick because of the particular job that you do as compared to everyone else in the general population, like a healthcare worker, then you might have a workers' compensation claim. At least in the state of Florida, it's not that clear, and I would encourage you to obtain legal advice on that particular aspect. I've put some slides in here, but because we're kind of running a little overtime, in part because of our little technical snafu, I'm going to go through those pretty quickly. All right, so there are a lot of questions and answers, so I'm just going to read out loud some of the questions that I've been asked, which is, I'm homesick with what feels like the flu. Am I entitled to be paid under the new paid sick time law? So the answer is probably not, because the sick leave provision of this new coronavirus response sick time law doesn't apply to all healthcare circumstances, although I would say there is a part of the statute that applies to similar types of illnesses. So it's a possible yes, but more likely a no. And so I know everyone wants a bright line answer here, but unfortunately there just aren't any just yet. But as this trickles down, we get a few more days underneath our belt and the DOL starts to issue some of these guidelines, I think we'll have a better understanding of when the circumstances are. And what I'm talking about is Section 6 of the Sick Leave Act that says if an employee is experiencing, quote, any other substantially similar condition, they might be entitled to sick leave time. All right, some other questions. What about PTO? This is a question we all have. If an employee has PTO, they can't be forced to use that PTO if they're just on sick leave, but the employee can elect to use their PTO if they're taking a family leave. And remember, the FMLA expansion only adds one type of protection. It allows people who are home to care for children whose schools and daycares have closed. So in that FMLA situation, that employee can elect to use their PTO to cover those first 10 days, which are unpaid. That's fine. All right, next question. My employer, a hospital, is not providing me with a COVID-19 test. They told me I have to go to my personal health care provider. Why doesn't my employer have to give me a test? So this raises a couple of different questions. One is we don't have enough tests for everyone to get tested. For that reason, there are specific protocols which dictate who is going to get tested and who is not. And under the circumstance of this question, it would sound like maybe there isn't any reason to test this employee. Diagnostically, the test doesn't tell us anything. In other words, there's no treatment for COVID-19. So knowing whether you have it doesn't help your healthcare provider treat you any differently. Of course, we all want to know how many cases there are, and that might direct data and help people decide, how to handle flattening the curve, so to speak. But from an employment law standpoint, the answer is your employer does not have an obligation to give you a test. And I would just say, as someone who's married to a first responder emergency medicine doctor, please don't go to your healthcare providers or the hospital to get a test unless you're having significant symptoms. Respiratory distress. So there's just simply not enough tests for everyone to go around, and we don't want people coming into the emergency room, one, because they could get sick, two, they could infect others, and three, they're going to take precious resources away from what's already an overstressed healthcare provider. Okay, next question. Let's see, my employer is considered an essential business and allowed to operate during COVID-19. I don't feel comfortable going into work. Can I be fired? I am not sick, but I am concerned. So I was just asked this question by a flight attendant. Of course, flight attendants are covered by a collective bargaining agreement, which I didn't cover in this presentation. That's going to be a different day. But no, you don't have the right to decide that you don't have, that if you feel uncomfortable, you don't come to work. I mean, that is a personal choice you can certainly make, but you will not be protected, at least in the state of Florida, if you are terminated. So let me just say that again. If you're fired because you refuse to come to work because you don't feel comfortable, because your employer is an essential obligation, there likely is not a claim, under, at least under Florida law, for wrongful discharge. It might be, in California, it might be different. I think that would raise questions, though, under the Americans with Accommodation Act as to if you have a medical condition that makes you feel uncomfortable and there are reasonable accommodations that could be made, then we need to look at those. So if the issue is, oh, well, I have asthma, so I'm at a higher risk, so it's not that I'm just afraid to come to work. I'm afraid to come to work because if I get sick, it's not the same for me as everybody else. And so in that situation, if you have a qualifying condition like asthma, then the employer could say, well, maybe what we could do is change your hours to have you work where there's fewer people there, or you could work more in isolation, you could work remotely. We could take a look at some of those accommodations that can be made. All right, so I think I'm pretty much out of time here. I do appreciate everybody's attention. Please know that the firm is here as these questions continue to arise. We're here to help you navigate through this. We're here to help you understand how to handle these situations as they come up. Please feel free to post comments on the Scott Wagner Facebook page. We will respond generically without getting too much into the details of your personal situation. You can also contact the firm directly by email or by phone to schedule a consultation. Thanks, guys, and everybody stay well.